Thanks to Shopify for supporting Future Hindsight. Shopify is a platform designed for anyone to sell anywhere, giving entrepreneurs like us the resources once reserved for big business. Sign up for a $1 per month trial period at shopify.com/hopeful, all lowercase. And thanks to Aura for supporting our show. Go to aura.com/protection for a 14-day trial, plus a check of your data to see if your personal information has been leaked online. All for free. Welcome to Future Hindsight, a podcast that takes big ideas about civic life and democracy and turns them into action items for you and me. I'm Mila Atmos. It's 2024, and the future of America is in your hands. Democracy is not a spectator sport, so we're here to bring you an independent perspective about the election this year and empower you to change the status quo. As a pro-democracy podcast, we're always interested in equality, whether that is in political equality, economic equality, or equality under the law. There are incredible citizen changemakers whose dedication to justice is exemplary and impactful. One of them is Stephen Bright. He has dedicated his career to represent clients whom society has long discarded, the indigent on death row. We've spoken to him twice here on the podcast, most recently in the fall of 2023 when he published his book, The Fear of Too Much Justice. Our guest today has written an homage to Stephen Bright's work, giving us an opportunity to dig deeper. Robert L. Tsai is the author of Demand the Impossible, One Lawyer's Pursuit of Equal Justice for All. He's also professor of law and Harry Elwood Warren Memorial Scholar at Boston University School of Law. We had Robert on the show back in 2019 to talk about his book, Practical Equality, Forging Justice in a Divided Nation. Welcome back, Robert. Thank you for joining us again.
It's great to be back with you.
So today I was thinking about how we're looking at, in theory, equality under law is foundational to American democracy, but we're not really there in practice. And this is an election year. We're consumed by horse race reporting, campus protests, so it's really hard to focus on anything else, including equal justice under law. But why is it important to have this conversation right now?
It's important because for so long, the problem of unequal justice has actually been the focal point of national politics. We've just sort of forgotten about that. One of the things that I tried to bring out through the book about Steve Bright's legal career is to put his life's work in a kind of political context. And he shows up as a cause lawyer right at the beginning of the war on crime years. And it's in those years that the war on people sort of come to power on the backs of the imagined offender lurking around every corner. And we have all of these policies, both at the state, local, and now at the national level, which we've only just begun to chip away at. So I think that's one reason why we need to make sure that it is part of the national conversation, even as we look in other places where progress can be made.
Well, just to ground us here, what is equal justice anyway? Because I think people have varying concepts of this, and I'm thinking here, of course, that Trump is getting more than equal justice. So how would you define it to a layperson?
Yeah, I think your invocation of President Trump as getting much more justice than the average person would is spot on. But we do have an ideal that is reflected in our Constitution. It's also reflected in at least modern cases, that if you're a poor person and you can't afford to hire your own attorney, you can't afford to hire the biggest law firms in New York City, for example, the state will provide you someone who is competent, knows something about, say, criminal law, and help make sure that, you don't get railroaded. At a minimum, that's what most of us agree on. But even that minimum idea of equal justice under law, we've had a hard time making that a reality in so many places. One way to think about why that's the case is that although we have this ideal, the Supreme Court of the United States has really left it to every local jurisdiction to find its own way to sort of come up with the funds and the structure to provide legal services for indigent people. And in many of these places, they do even less than what most people expect they'll be getting.
Right. Well, this is definitely one of the things that really stood out to me, that in your book and also from, talking about law in general, I think there's very little understanding of how the law works and how it is that state by state, county by county can differ, and how at the end of the day, though, you can go to the Supreme Court and appeal those decisions. Can you talk a little bit about these technical things, just because I think that would be really great for the audience to learn?
Sure, absolutely. Most lawyers and judges know about a case called Gideon versus Wainwright, and I think this is a case, it's a Warren Court case. It's one that really embodies this aspiration of equal justice under law. Gideon was poor, charged with breaking and entering, and he couldn't afford his own lawyer. And under Florida law, they did not provide someone like that with a lawyer. And so he had to represent himself. Of course, he winds up in prison. And this case goes all the way up to the Supreme Court of the United States, and the Supreme Court, for the first time, really said to the states in a meaningful way, you really got to do more to fulfill this noble aspiration of equal justice. But the problem is that ever since that decision, there hasn't been much to back that up. One way to think about this, again, is to think that there's a sort of political economy of injustice in place, that if you're going to have a mandate like that, and it's kind of an unfunded mandate, and you also don't tell states how they're supposed to comply with the constitutional guarantee, then they're going to choose the least costly and least cumbersome way to do it. So the image that we get on TV, for example, shows like Law and Order, where you've got a prosecutor who's well-funded on one side and a public defender that is well-funded on the other side. This really is a fiction in most parts of the country. It exists in the major metropolitan areas, let's say, but in virtually every other part of a state, you'll have something else patched together, a pure court-appointed system where a judge will just appoint basically commandeer a local lawyer who may or may know anything about the criminal matter that someone is being prosecuted for. Or you have something called a contract system where, say, a county will entertain bids and to see who will come in and represent all the poor people in the jurisdiction at a kind of a bulk rate. The problem with these systems, the first is you often get people who don't know anything about criminal law or don't care about their clients. The contract system often has people who represent hundreds and hundreds of clients at a time, and so there's even more incentive to do no investigation and to do very little and just try to plead people out.
Well, I feel like the system just is, in a way, designed to prevent equal justice. That sounds wrong, but for sure, that has been my takeaway for a while. And in addition to not having access to good counsel, there are other problems like peremptory jury strikes, no good, terrible prosecutors who hide exculpatory evidence and such, not to mention racism. But in the book, you talk about the example of Georgia and the creation of a statewide public defender system. Tell us a little bit more about how that works and how competent counsel really actively prevents unjust outcomes.
Yeah, I think this is really an important moment of history, but it's also a kind of climax moment for the development of Stephen Bright's career because, once he starts taking cases in the criminal justice system on behalf of poor people, he's intensely focused on trying to get them to the best outcomes. And so if it's a poor person who's charged with a capital crime, it's trying to find some way to get to a life sentence for that person. And all of his attention is focused on the ins and outs and twists and turns of those cases. But along the way, and this is one of the emphases of my book, is to show the sort of set of constitutional arguments that really start to work and that he really starts to develop during his career. Arguments about incompetent lawyers that are produced and are sort of foisted on poor people, the kind of god-awful representation where someone could be on trial for their life and even say, there are people who saw me elsewhere, they have an alibi, and their court-appointed lawyer doesn't bother to even go find this witness, or a person has been abused and There's some evidence of intellectual disability, but again, no effort to sort of corroborate these kinds of things or put it in front of a jury when they're asked to decide life or death. So there are these kinds of things that he works with in terms of the ideas, and all of these things, including the things you mentioned, the places for discrimination by prosecutors, manipulation of juries, such as the manufacturing of all-white juries. These are sort of showcasing the various defects of the criminal justice system, all of which get magnified during these war on crime years, starting roughly late 60s through the early 70s, when all of these policies, state, local level, and then becomes part of national policy, come cascading down on top of the poor people in these systems. Mm-hmm. So let me just answer that part of your question about Georgia. So this is sort of the place where Bright and his organization, the Southern Center for Human Rights, they know Georgia the best. They know the court system inside and out. They've represented a lot of poor people in the system that have faced sort of the worst. And they sort of sense that the issues that they've been showcasing, the kind of flaws in the criminal justice system, have started to percolate into the political discourse. And there's this sort of moment kind of leading up to 2003 where there is significant interest and people are really just appalled by, not only the big things like a person on death row after a prosecutor manufactures an all-white jury, but also the everyday things. There's these stories that come out where a poor person is, for example, picked up for loitering and then just gets lost in the criminal justice system during pretrial detention. And he's there for many, many months because he can't afford bail and he can't afford his own lawyer. So people just sort of forget about him. And he hasn't even actually been prosecuted for anything. He's just lost in the system. And so right around that time, people are sort of focused on the problem of legal services for indigent people. And even though Georgia is a red state and they had a new Republican governor, they were able to create for the first time a statewide public defender. It still has issues. The biggest one is funding, but it created a framework and a set of aspirations that the system can then get held up against. And one of the places where it's probably had the most success is it's reduced the ability of judges and prosecutors who want to speed someone to the execution chamber. It's reduced their opportunities to sort of exploit the system and saddle people with terrible lawyers.
Well, one of the things that I noted as well is that the capital cases are really expensive, which I was really not aware of. And so once Georgia created this public defender system, the robust public defender system, it kind of put the state on the hook to mount a rigorous defense for the accused, which costs even more money. And so I thought, wow, this is an interesting it creates a virtuous cycle for justice in a way that I had not previously considered.
Yeah, it is interesting. It does cost something to match one's aspirations, which we haven't always been very good at. One thing that advocates on the ground told me was, especially in the early decades of the war on crime, where racking up death sentences was often a way for prosecutors to become judges and for ambitious elected officials to sort of win higher office, is that they took advantage of the asymmetric quality of the system. There's always resources for the prosecution, for investigation, and very little for the other side. And according to advocates, that's exactly how people in charge wanted it. They wanted to keep the system as unequal as possible structurally so they could get as many death sentences. They wanted to get there as cheaply and as efficiently as possible. But you're right that if you really do care about equal justice, you do have to think about things like mental health services, what it means to really give enough evidence to a jury about a person's life to make this weighty decision, to ensure they've got all the information they need. And that does take representation. It does take people willing to find out how a person got to this horrible place where they've done something god-awful, but also to understand that this is how we fulfill our belief in equality and fairness.
You mentioned people with intellectual disabilities and how they're entrapped in a system that they frankly don't really understand how they got there. They don't understand what they're charged with. They don't understand that they might be condemned to death. And you cite a shocking statistic that at one point, nearly 1/3 of the people on death row in Mississippi had a verbal IQ below 74. And when you talk about how unfair this is, What is a case that you like to point to that sheds light on the problem?
Yeah, one of the cases that I hope will provoke your listeners and my readers to think about how much more work has to be done to make the criminal justice system more fair for people who might have intellectual disabilities is this case, McWilliams versus Dunn. It's the fourth case that Stephen Bright argues in front of the U.S. Supreme Court. My book is organized around the four cases he argues and wins, but I start the book with this case because in many ways it's the hardest case of all to win. He brings it at a time when all of the developments in the law have made it harder to get these kinds of issues, I think, handled fairly. Even the issue of intellectual disability has to overcome all these hurdles by the time Stephen Bright gets involved in this case. You've also got a Supreme Court that has become now incredibly conservative and really doesn't want to get to the merits of these kinds of issues anymore. Their attitude is someone else must have had a chance to look at it, so we're not very interested. So I begin my book and I end my book with this case. And basically what happens to McWilliams is he's given a court-appointed attorney. He obviously is accused of killing somebody. And right before sentencing, his lawyers finally get a report, which is by the state's own medical people, that suggests that he's got some kind of organic brain damage. And they don't understand the report. They have some difficulty figuring out how much this really changes things. And so they asked the judge, should we ask for an expert to help us? Should we ask for a recess? And the judge just says, stand up with your client, and sentences him to death right there. I hope that's the kind of scenario that makes people sort of gasp. But it's also, in many ways, not surprising given the structural problems that you and I have been talking about, right? One of the things that happens in these places where you have court-appointed systems and no public defender is that a lawyer has to beg the judge for every penny that they might need or want to do investigation. And that's kind of a huge hassle, and judges may be annoyed, especially if they're ready to sentence somebody or they've developed sort of assumptions about an individual. And that's probably what happened here. So no one really knows the full sense of what's contained in this report, how damaged McWilliams really is, because the judge is not interested in hearing anymore.
Right. Well, I think that points perfectly also at the problem that you talked about earlier, that there is asymmetry in the system. Prosecutors have so much power. Judges have so much power. When you talk about this to lay people, of course, not lawyers, they understand, how would you describe the structural advantages of the prosecution?
Well, I think the structural advantages are many. One, it starts with formal power, which is all of the discretion is in the hands of the prosecutor to decide whether to charge, what crimes to charge. For death-eligible crimes, whether they're going to seek the death penalty or not. That's tremendous formal power. There's also the question of resources, especially during the post-war and crime period. Really, there seems to be an endless amount of resources for a prosecutor's office, for salaries, for investigation, for paralegals, for police. And on the other side, very, very little. Again, you may not have a public defender at all. You may have a contract system or a pure court-appointed system. So on one side, you may have incredibly experienced prosecutors who know criminal law very well and handle a bunch of cases. On the other side, someone who maybe has never even tried a criminal case and is handling a capital trial for the first time. When I looked at some of the cases that Bright got involved in and his staff got involved in, they often look like those kinds of cases. This is sort of shocking that even in the 80s and 90s, you could see such deep imbalance in terms of formal power and resources.
I mean, I have to say, the 80s and 90s are really a long time ago now. Although when I think back of the 80s and 90s, I think it's just, 20 years ago. But it's much longer. So what would be a more just system? That's the question that I had over and over while I was reading your book. And you point to the California Racial Justice Act as one bright light. It was signed into law in 2020 and attempts to address the disparities of outcomes for minorities. How has it worked? Do you like it? Should other states think about it? Tell us more.
Yeah, so, I think a lot can be done. It's a complex animal with lots of different parts to it, all of which need some attention. And certainly, in terms of once someone is actually charged of a crime and they're sort of pulled into the system. I really do think that Bright is right about this, and we really need to revive the public defender movement. So at one point, this was quite a crusade for legal professionals and progressives who are politicians and so forth to push these structural changes and to create public defenders' offices. And this kind of waned, and I think that there is much that can be done. And Georgia's a good model because there it's not really led by elites. Elites have the formal power to change the structure of the system, but a lot of the energy to do it was presented and pushed and kept alive by grassroots advocates, the Southern Center for Human Rights, but other organizations, other advocates, other people on the ground. I think that what you mentioned, the Racial Justice Act, is something that can be helpful in two ways. There's only been a handful of these, but I do think that the one in California is probably the most far-reaching experiment, and it's well worth watching. But the Racial Justice Acts basically repudiate a kind of very parsimonious set of cases that has been decided by the U.S. Supreme Court about racial equality in the criminal justice system. And, without going too deeply into this, these cases were deeply demoralizing for people who believe that there is too much unequal justice in the system. And these cases largely protected the prerogative of prosecutors and protected the policymaking discretion that you and I have been talking about, and made it incredibly difficult to mount any kind of equal protection challenges within the criminal justice system. So the California Racial Justice Act, just to take as the best example, repudiates that vision of equality and says, to tell us that we should get used to all of these racial disparities is a corrosive message. We repudiate that message. Instead, we think that if there is a single criminal conviction in our state where there has been racial discrimination by prosecutors or judges, that undermines faith in the rule of law. And so it's this kind of an incredible communal statement about how the quality of justice should be different. And in terms of the specifics, though, what it does is it sweeps away a lot of judge-made law and procedural law created by legislators within the state that make it incredibly difficult to bring constitutional challenges after somebody has been convicted. And so it makes it easier for someone to go back, try to argue that, say, the prosecutor used race to strike all the people of color from the jury, or made racist arguments in court to the jury to inflame the jury. All of these kinds of things now can be more easily brought to bear and perhaps lead to a new trial or a new sentence.
We're taking a short break to thank our sponsor, Shopify, and we'll be back with Robert in a moment. But first, Homer and Marge, Bart and Milhouse. What about the perfect duo when it comes to growing your business? That's you and Shopify. Shopify is the global commerce platform that helps you sell at every stage of your business. From the launch your online shop stage to the first real-life store stage, all the way to the did we just hit 1 million orders stage? Shopify is there to help you grow. Whether you're selling scented soaps or offering tie-dye headbands, Shopify helps you sell everywhere. You heard that right. From their all-in-one e-commerce platform to their in-person POS system, wherever and whatever you're selling, Shopify has got you covered. Shopify also helps you turn browsers into buyers with the internet's best converting checkout, 36% better on average compared to other leading commerce platforms. Sell more with less effort thanks to Shopify Magic, your AI-powered all-star. Shopify powers 10% of all e-commerce in the United States. It's the global force behind Brooklinen, Rothy's, and Allbirds, and millions of other entrepreneurs of every size across 175 countries. Plus, Shopify's award-winning help is there to support your success every step of the way. Because businesses that grow, grow with Shopify. No matter how big you want to grow, Shopify gives you everything you need to take control and take your business to the next level. And that is what I love about Shopify. Sign up for a $1 per month trial period at shopify.com/hopeful, all lowercase. Go to shopify.com/hopeful now to grow your business no matter what stage you're in. Shopify.com/hopeful. I want to tell you about a podcast called 10% Happier. The 10% Happier podcast has one guiding philosophy. Happiness is a skill you can learn. So why not master it? Hosted by Dan Harris, a journalist who had a panic attack on national television and then set out on a journey of transformation. He's now on a quest to help others also achieve peace and happiness. Every week, Dan talks to top scientists, meditation teachers, and even the odd celebrity in wide-ranging conversations that explore topics like productivity, anxiety, enlightenment, psychedelics, and relationships. The interviews cover everyone from Brené Brown to Alexander Draymond to Sam Harris. Think of listening to 10% Happier as a workout for your mind. Find 10% Happier wherever you listen to podcasts. It feels like there's a major leak of personal information just about every week, doesn't it? It's easier than ever for data brokers to get your data legally from public tax records, credit card companies, cable and internet providers, and sell it to anyone who will buy it, even scammers. Your information, your full legal name, email, home address, phone numbers, credit card info, and more can be easily found online. That's why I want to tell you about Aura. Aura is a great way to try out a great VPN. It's the all-in-one online safety solution that helps protect your information. Aura is offering you a 14-day trial plus a check of your data to see if your personal information has been leaked online, all for free, when you visit aura.com/protection. And that's not all. Aura is a great tool that monitors identity theft, financial fraud, and other online threats before they happen. With Aura, you can rest easy knowing that someone is looking out for you. Aura scans the dark web to look for your email addresses, passwords, social security numbers, and other sensitive information. If anything is found, you'll receive an alert in real time. And it's really easy to use. Aura offers a suite of tools to protect you, including real-time alerts on suspicious activity, computer virus protection, a VPN, password manager, and even parental controls. And hey, if you're looking for a gift for someone in your family, this will be a really unique and usable one, and it will give them the protection they need online. I'm thinking about giving it to my cousin. For a limited time, Aura is offering our audience, you, a 14-day trial, plus a check of your data to see if your personal information has been leaked online, all for free when you visit aura.com/protection. That's AURA.com/protection. Certain terms apply, so be sure to check the site for details. And now, let's return to my conversation with Robert Tsai. The work of Stephen Bright is amazing in order to save the lives of the people who've already been sentenced to death. But why does the U.S. still have the death penalty, and how does capital punishment fit in with democracy?
This is a great question. How do we still have the death penalty when virtually the rest of the Western civilized world has gotten rid of it? I'd say that our federalist structure has a lot to do with it. Virtually all of criminal law and policy, with the big exceptions, the stuff really during the war on crime years where federal crimes went way up in terms of making new crimes and so forth. That leaves in place a lot of discretion in the sense that decisions should be made at the local level. And so when the Supreme Court of the United States in the early 70s thought that the country was in an abolitionist moment, and in a case called Gregg versus Georgia struck down all of the death penalty statutes across the country, there was a kind of political reaction in many states against what the court was doing. So I think unlike other countries where you either had judicial abolition or at least some largely elite-driven form of abolition of the death penalty, it's very difficult to get that accomplished in the United States, where we, ironically believe in much more populist, much more democratic control over the law. much more progress has been done incrementally and in each of these states. Probably the most striking thing is Virginia recently abolished the death penalty. And that's noteworthy because historians credit Virginia with being the first state in this country to have executed somebody. And they've also been among the most enthusiastic killers of its own citizens. So for Virginia to repudiate the death penalty and say, we don't need this anymore, I think is a pretty interesting. So we'll see. I mean, I think for those who are abolitionists, that's a real win for their side. How to get there? I think to continue on this path is probably most likely to get to a kind of position where people see some symbolic value in perhaps having it on the books. But as a lot of social scientists are telling us, the mood has changed. People do see the flaws in the criminal justice system today when they were probably less apt to see them even a couple of decades before. And that means when they're asked to sentence someone to death, they're showing that they're much more reticent to do it. So that may be the best that we can get until something pushes the community over into the abolitionist column.
Well, that's a good point that they're more reticent to sentence somebody to death. But we do still have people on death row. And during the Trump administration, of course, he gave the go-ahead to execute prisoners on federal death row after that had largely fallen out of practice. What do you expect to happen if Trump were to be reelected?
I'd expect more of the same. He has, in his speeches, indicated that he believes that Rudy Giuliani was one of the greatest mayors of all time. Giuliani, as I talk a little bit about in the book, as mayor, was very much at the forefront of developing war on crime rhetoric and war on crime policies. And even though New York City, of course, doesn't have the death penalty exactly, he was one of these politicians that came to power in those years. And there are Democrats, too, people like Bill Clinton, that tried to show how tough they are by talking a lot about the kinds of people that they're willing to send to the execution chamber. I expect that we would see him call for even more aggressive enforcement of existing criminal laws that are federal. And if there's anybody on death row, that he can sort of nudge towards the execution chamber. I'd imagine that Trump would do more of that, as president.
Well, I'm also wondering in this context about states that have criminalized abortion. There, of course, women are charged with murder. So if you take this to its logical conclusion, all of these women and their doctors are at risk of being sentenced to death. How do you think about this?
Yeah, so, I think that the Supreme Court's decision to overrule Roe versus Wade suddenly opens this huge Pandora's box that I think the court itself can't fully imagine all the problematic legal issues that are going to have to be confronted now. And let me just say this. Right now, they're just dealing with some of the stuff that is tricky but obvious, like mifepristone and, FDA regulation of that, or the Comstock Act, right? But now you've got these jurisdictions who have become invigorated that, as you say, might want to try to push the envelope and bring back long prison sentences and maybe even try to bring back the death penalty for abortion if that's their biblically inflected view of justice. Now, will the courts go along with it? I want to think that this is something that is not well solved, but that whether at the state courts or whether it's the U.S. Supreme Court eventually having to confront something like this, that they might have other tools that they would use even if they didn't bring back the right to abortion. So you might be able to say that it's cruel and unusual punishment. You have some cases where, for example, executing somebody for rape was deemed cruel and unusual, and those cases have not been disturbed by the Dobbs decision, for example. So I'd imagine that there would be some effort to try to bring some of these other concepts or principles in play to try to deal with the extremes if they appear.
Right. Well, I hope you're right, because otherwise, we're all doomed in a way, because if it's okay to sentence a woman to death for having an abortion.
And even if it's not that, I think it's good to force the judges to confront the fact that there is extreme physical and mental anguish associated with coerced pregnancies. Mm-hmm. And it's quite clear that the Supreme Court was completely indifferent to that as a pragmatic matter, as a humanistic kind of question. And so more stories about the horrors that people have to go through to get people's attention here and get the medical care they need, I hope will freshly sensitize people again. I mean, you got these justices basically that for how many years since they were in law school and in the smaller quarters in which they've spent their time have convinced themselves that Roe versus Wade is one of the great legal travesties, right? They're so focused on that and not anything else. And I think that hopefully they'll be able to see something more about the world.
Well, it's well put. I think that they're removed from the everyday life of everyday people, it appears. So speaking of Supreme Court justices, how do you think about the role of the Supreme Court in capital cases? Of course, your book is about 4 Supreme Court cases. I kind of feel like there's another disconnect there, that people have a feeling that if all else fails, they can go to the Supreme Court to appeal. But that's not necessarily the case. And I also know that there are many cases where even if you get there, you might still not get a stay.
I think that's right. I did not want to convey the sense that every injustice is going to be dealt with by the U.S. Supreme Court. It's quite clear that over the years, the Supreme Court of the United States has taken a smaller and smaller number of cases on appeal. They've created a whole bunch of procedural rules on their own, and then they've stepped out of those rules and asked Congress to help create more rules so they can avoid taking cases. I do believe that there is a place for what we might call error correction, right? That when some lower court, some trial judge, or some prosecutor crosses the lines, that there is a place for the U.S. Supreme Court to step in and fix things and give someone another chance. I don't think that people should be sort of persuaded that this can happen all the time. But B, I wanted to really focus attention on all of the obstacles that the court itself has created. The court itself and judges generally deserve some of the blame for facilitating the war on crime. But I did want to show that the justices themselves have gotten annoyed being woken at night by some person's last-minute, last-ditch appeal to them, and that they kind of got involved asking Congress to, for example, make it easier for them to sort of say no and get rid of these cases without ever having to give someone their day in federal court at least. The problem with that, though, of course, and this is illustrated in a lot of things that Stephen Bright has written and talked about, is that leaves then some of these manifest injustices where they are. And it's kind of a miracle, for example, that in his first case representing Tony Amadeo, who is 18 when he winds up on death row, and they have clear evidence, what I call smoking gun evidence, of systematic effort to minimize the number of women and black people on juries in this county, that they have to work so hard to get this piece of evidence into the case, and they're trying to deal with all these rules that have been made, and it's basically just by the skin of their teeth that they get enough justices to even become interested in hearing the case. That's one of the things I want to capture, and hopefully that will provoke people to think harder about whether we need reform of some of the things that are still in place.
Well, for sure, I think we need reform. I don't think people need to be persuaded. Even the person who's not interested, I think, feels that things are not fair. But most people are not lawyers like Stephen Bright. That's the good news for most of us. I think it's very hard to be Stephen Bright. But as an everyday person, what are 2 things I could be doing to demand equal justice, or even to go as far as to demand an end to the death penalty?
Well, I think that on the equal justice front, the racial justice acts are a good way to get everyday people involved. You can find travesties of justice locally and focus attention on a kind of legislative outcome that can become meaningful. And then also once you have that in place, you start to hear more stories about the various problems that people, don't think exist but are rampant through the criminal justice system. To me, that's an important one. We've talked about the public defender movement. I think that's a harder thing to kickstart, but there are these places, and if you happen to live in one of these places, I just wrote a little thing about Louisiana, which has a statewide public defender system, but the current governor, with the help of the current person who has been tapped by him as the chief public defender, who's actually a former prosecutor, they're involved in basically dismantling what is there. So if you live in a place like Louisiana, then I think, you've got to sort of find ways to fight what is the taking apart of these achievements that can at least get their legal system a little bit closer to the notions of equal justice. But I think things are going to get a lot worse in places like Louisiana before they get better, but that's where a lot of work can be done. In terms of Ending the death penalty, I think that's an interesting one. I do think that my book, if you read it from beginning to end, will illustrate the kinds of arguments that go beyond the abstract moral arguments, like whether it's morally right to kill somebody or not, whether the death penalty deters. These are kinds of arguments that everybody's heard about and maybe even used, but my book tries to really probe the possibility that really what's moving people towards abolition are some of the arguments that advocates like Bright and Brian Stevenson and others that appear in the book have marshaled, what we might call the practical or pragmatic arguments about how the death penalty is actually enforced. And I think there's lots of evidence that these arguments may actually reach mainstream voters better than the abstract moral ones. That racism and racial disparities are too strong, that there's too much geographic variability in who is really at risk of a death sentence and who isn't. And then the asymmetries that you and I have been talking about, where it's just too possible for a person to be essentially railroaded onto death row. And that remains the reality, so that if a community isn't going to actually put enough resources throughout the state to make it a fair possibility, then maybe this risk that someone may be executed because of these structural defects is too high a risk to sort of tolerate. Places like Virginia, California, Washington State have reached that conclusion. They no longer think they need the death penalty. They think that the risk of bias and irrationality outweigh whatever might be gained from it.
All good advice and good highlights. So as we're rounding out our conversation here today, looking into the future, what makes you hopeful?
Well, what makes me hopeful are people who I think have been able to reach outside of their ideological silos to be able to reach people that they need to convince in order to make progress on issues of social justice. In my book, I talk a little bit about a justice of the Georgia Supreme Court. He's a white guy who grew up in a rural part of Georgia, really didn't have any criminal law experience before becoming a judge. And in my interview with him, he basically acknowledged to me that there was a kind of educational process for him as Steve Bright and his staff and others brought these cases that sort of illustrated the horrible structural defects in the criminal justice system in Georgia. And eventually, this caused him to change his mind about the death penalty. He said he essentially had a conversion after having to read the transcripts and listen to the arguments over and over, and it brought him to an abolitionist place. So the reason why I have that in the book is because I really do think that social justice advocates have to be able to reach people like former Chief Justice Norman Fletcher in order to make progress.
Yeah, that's right. Hear, hear. Thank you very much, Robert, for joining us on Future Hindsight. It was really a pleasure to have you back on the show.
It's so great to be back with you, and I can't wait to listen to the episode.
Thank you. Robert L. Tsai is the author of Demand the Impossible, One Lawyer's Pursuit of Equal Justice for All. Next week on Future Hindsight, we're joined by Wajahat Ali. He is a Daily Beast columnist, co-host of the Democracy-ish podcast, and senior fellow at the Western States Center. His book is Go Back to Where You Came From, and other helpful recommendations on becoming American. That's next time on Future Hindsight. And before I go, first of all, thanks so much for listening. If you like this episode, you'll love what we have in store. Be sure to hit that follow button on Apple Podcasts or the subscribe button on your favorite podcast app, so you'll catch all of our upcoming episodes. Thank you. Oh, and please leave us a rating and a review on Apple Podcasts. It seems like a small thing, but it can make a huge difference for an independent show like ours. It's the main way other people can find out about the show. We really appreciate your help. Thank you. This episode was produced by Zach Travis and me. Until next time, stay engaged.
This podcast is part of the Democracy Group.